Tēnā koutou, tēnā koutou, tēnā koutou katoa. Maku te karakia. Whakataka te hau ki te uru, whakataka te hau ki te tonga, kia mā kina ki uta, ki mā taratara ki tai. E hi aki ana te atakura, he teo, he hoka, he hauhu, ti hei mauri ora. Nā mihi o te pō, nau mai haere mai ki tēnei hui. E mihi ana ki ngā wahi taonga o tēnā rohi, ki te maunga ahu mai rangi, ki te awa pipitia, ki te moana te whanganui a tara. E mihi ana ki ngā mana whenua o ngā iwi o te atiawa o Taranaki whānui, me Ngāti Taua rangatira. E mihi ana ki te kaitōtoku o tēnei hui, ko Peter Salmon. E mihi ana ki te kaikōrero i tēnei pō, ko Judge Newhook. E mihi ana ki a mātou manuhuri kua tae mai ki konei i tēnei rā. E mihi ana ki te kaupapa o tēnei hui. I rua te kaumā rima tau i haere ngā tangata ki era hui, ki ka rongo tātou i ngā kaikōrero o te kaupapa o Ture Taiao. Ka mutu au e whakatauki nā te koti arikirangi. E ki ana te whakatauki, ka kuhu au ki te turi, he matua mō te pane. Ko Kate Tokuingoa, ko kaihautu au o te whanganui a tāra wahanga o te kahui turu tau. Good evening, everybody. For those of you who I haven't met, my name is Kate, and I have the privilege of welcoming you all here tonight as the chair of the Wellington branch of the Resource Management Law Association. So first of all, a very warm welcome to this evening's speaker, Judge Laurie Newhook, and of course a particular welcome to the Honourable Peter Salmon KC, in whose honour we hold this annual Salmon Lecture. So as many of you will know, the Salmon Lecture was established in 2002 to honour Peter's extraordinary contribution to the resource management law of New Zealand. And this evening is actually the 25th time we've gathered for this event, and we're delighted to once again welcome Peter for this occasion. So as most of you will be aware, Peter Salmon has had a distinguished legal career. He's a retired High Court judge who has also served as an arbitrator, mediator, resource consent commissioner, and on the Pacific Islands Court of Appeal. Before his appointment to the bench, he practiced as a barrister for over 2 decades, specialising in local government, environmental and resource management law, and was appointed at that time Queen's Counsel in 1983. And then from 1996 to 2004, he served on the High Court, but since retiring from the bench, his leadership has continued. Tonight's lecture really continues in that tradition of excellence, with Judge Newhook becoming the 25th presenter in this series. Now, just before I do hand over to the Honourable Peter Salmon, just a couple of minor admin details. If you are online, you can ask some questions by clicking on 3 small dots on the bottom right-hand corner of your screen, and we'll pick up your questions at the end. Everybody else, hold your questions to the end, and then we will have a roving mic to pick those up. And I've also been asked to mention that we do have the Salmon lectures in a book, which are available for sale, so please hit up Michelle if you would like a copy to take home. And with that, I'd like to hand over to Peter Salmon. Thank you.
Thank you very much for that introduction. And tēnā koutou katoa. It's great to be back here again, and welcome to all of you who have come along on this rather cold Wellington night. But what does one expect? Now, introducing Laurie. He really doesn't need an introduction because he's been around the environment field for so many years that I'm sure that most of you have either appeared before him or appeared against him or in some way or other had something to do with him. And so often people introducing people say, he needs no introduction. So I'm going to go with the majority and continue to make an introduction, of course. In his early years, Laurie was a foundation director of ADS, appointed by or nominated by the law school. That was a very important start both for EDS and for Laurie. EDS, I've been associated with them for many years too, and they do a wonderful job as guardians of the landscape. He acted for EDS and other groups before the Planning Tribunal in cases on the Coromandel, and perhaps I'll give a little push for Environmental Defenders by Raywin Peart, which is an excellent account of the history of EDS. Another planning and other matters issue that Laurie was engaged in, and so was I, is, for better or worse, getting permissions for the both planning and licensing for the Sky City Casino and the Sky Tower. It was an interesting time in my life and probably Laurie's as well. I do remember that one of the things I insisted that they do was to have a theatre there. I thought that might help. Anyway, were you there, Laurie, when a certain gentleman who's since become the President of the United States? Were you there, were you? I don't recall him at all.
You're the better off.
It's possible, of course, that I wasn't there on that day when he came along. Maybe I did the sensible thing and stayed away. Anyway, getting back to introducing Laurie rather than me, the other important matters, and this was a biggie too, is involved in the zoning, the public works activities, and major resource management applications for Remarkables Park Limited in Frankton Flats, and anyone who's been there will be aware of what a major development that has been. He was appointed to the Environment Court in 2001, and then he did things in sort of 10-year blocks, because he was appointed head of the Environment Court in 2011, 10 years after he got there, and retired with the title of Chief Environment Court Judge in 2020, almost another 10 years. During the time he was on the Environment Court, he presided over a board of inquiry consenting 7 major roading proposals joined together entitled the Waterview Motorway, a tunnel, a motorway, a complex flyover system, and motorway widening, and many of you will be familiar with that, I hope. I hope you've been to Auckland, some of you. Anyone been to Auckland? He also, and I didn't know this, well actually I didn't know the first one either, but he also presided over designating and consenting the Auckland City Rail Link in 2013. I don't know why he didn't insist on it being completed sooner than it has been. But anyway, that was a major one too. Two more things worth mentioning. He presided over major and complex applications for consent to boat marinas on Waiheke Island, won one and lost the other. And he has presided over complex recent major tikanga-based decisions in Tamaki Makaurau. So that's a pretty impressive list of achievements in my view. But his life hasn't been only town planning and environmental matters, of course. He has a wonderful wife who came down on the plane with me. Hi, where is she? Right in the back row. Are you wanting to make a quick escape? Two adult children and 3 grandchildren. He's had a lifetime of yachting, including ocean yacht racing, and he taught, presumably, his 2 adult children to sail in P classes at Kohimarama, and he has a love of rare classic cars, and he owns 2 in mint condition. And I've had the good fortune to see one of them, a beautiful bright red, you can tell, Citroen SM Coupe. Most of you will know what that is, of course. Beautiful cars. Laurie was down there with a whole team of people in classic car. That's an organisation, I guess, Laurie, is it? Mm. And more down to earth, he's restoring a 20-hectare block of retired farmland on the eastern Coromandel Peninsula, revegetation of ridges, slopes and wetlands, subsequent weed and pest control. So, Laurie is going to speak to us tonight on access to justice for the natural environment. I'm sure that we're all fascinated by that title. Over to you, Laurie.
Tēnā koutou katoa. I won't endeavour to introduce myself further. Thank you for that generous introduction, Peter. It's fabulous that you, as the person for whom this lecture series has been made, was able to come and introduce me. Thank you, everybody, for your interest and attendance. I hope to make it worthwhile for you. As Peter has indicated to you, my topic is access to justice for the natural environment. Change slide, please, Hadley. So I'm putting 3 questions that will actually become 2 towards the end of my presentation, and I'll tell you why then. The first question, the easy part, should there be access to justice for the natural environment? Secondly, if so, how can this be achieved? Thirdly, challenges in legal and adjudicatory frameworks. So I'll come back to them in a moment. Change of slide, please, Hadley. My introduction. Environmental governance is, I think, subject to seemingly never-ending changes of policy settings around the world. Right now, the pendulum seems to swing almost as wildly as it ever has in the field, in New Zealand and elsewhere. That seems unfortunate for a topic that has been demonstrated in the past to be suitable for cross-party government collaboration. Remember the birth of the Resource Management Act, anybody? 1991, for those who've overlooked that. And Peter was there. A few of us, quite a few of us, were there at the time. So in 1991, it was passed by the country's then newly elected national government. The bill had been prepared by the previous Labour administration, Sir Geoffrey Palmer, as he now is, then Minister, inherited by National, modified a little, then passed into law, shepherded by the Right Honourable Simon Upton, as he now is, latterly the Parliamentary Commissioner for the Environment. Reads a little bit like a who's who. It's not my intent in this paper to enter upon political debate. Rather, I intend to explore the importance of the natural environment with a focus on protection of ecosystem biodiversity and the importance of that for the planet. So I'm focusing on ecosystem biodiversity, climate change and human rights in relation to these matters. Come into it on the fringes, but I've got to focus a bit, or we will be here rather longer than perhaps you would prefer. So I'm focusing on ecosystem biodiversity. After pondering my subject and drafting the lecture, I found no difficulty answering my first question in the affirmative: should there be access to justice for the natural environment? And you might think that that's a no-brainer, but I still feel the need to take you through my reasons for answering that question in the affirmative. I then combined my second and third questions and proceeded to consider matters, the answers to which were more painful. So, what is ecosystem biodiversity and what is its importance? Bear with me, it's quite a big topic. The legally trained among us in New Zealand have had drilled into us from the earliest years of the RMA the duty to honour the lodestar of Section 5 purpose of the Act and to recognise and provide for Section 6 certain matters of national importance, have particular regard to certain matters in Section 7 and to take account of the principles of the Treaty of Waitangi, Te Tiriti o Waitangi in Section 8. Before recording a little bit of jurisprudence on a salient feature of these provisions, I signal my intention to go behind the statutory expression in them to consider what their importance is in scientific, public policy and philosophical terms, because statutory words, as we know, can be ephemeral. I intend to consider the scientific, public policy and philosophical underpinnings because they are, in my view, key to answering my core question of whether there should be access to justice for the natural environment, and not just because the legislature has ordained so at some point. In other words, I feel the need to underpin my inquiry in a truly contextual way, as distinct from a purely legalistic one. So that might sound strange coming from a legally trained person, but I've had to listen to quite a few things other than law over time, and indeed practice in the field before that. As already signalled, I've chosen to focus this lecture on ecosystem biodiversity. That's not a term that appears in the RMA. The term is, however, interchangeably employed throughout decisions of courts and the academic literature, with such terms as diversity, indigenous biodiversity, biodiversity, simpliciter, biological diversity, and the varying language of the provisions of the RMA that I've just quoted. The interchangeability appears to have occurred in court decisions without problem or controversy. And in my paper, you'll see later, I've listed some quite notable cases in which I have found this occurring. The forerunner of the Environment Court, the Planning Tribunal, held in a 1995 decision in the Manawatu Whanganui region that by not providing a definition of ecosystems in the RMA, Parliament presumably intended that the word be given its ordinary meaning. And of note, an often cited early High Court decision, New Zealand Rail Limited against Marlborough District Council, the Honourable Justice Gregg held that the provisions of Part 2 should not be subjected to strict rules and principles of statutory interpretation, which aim to extract a precise and exact meaning from the words used. There is a deliberate openness about the language, its meanings, and its connotations, which I think, he said, is intended to allow the application of policy in a general and broad way. So there we are. We don't have to worry about the fact that biodiversity or variations on that theme doesn't appear in the Act. The courts have had no trouble with it, and neither have academic commentators. I want to turn now to public policy and scientific contexts. And I'm going to start with the 1992 Earth Summit in Rio de Janeiro, where it adopted the United Nations Convention on Biological Diversity. And I'm going to call that the CBD for ease from here on. It covered biodiversity at all levels, ecosystems, species, and the use of their genes, a comprehensive strategy for sustainable development, which we kind of tweaked to sustainable management in our Act. It's been adopted by most nations, just under 200, and was adopted by this country in 2020. In 2022, the CBD adopted the Kunming Montreal Global Biodiversity Framework, and I'll just call that the framework, which replaced the previous Aichi targets that had been set for 2020. It sets a pathway to spurring international action, it says, halting and reversing biodiversity loss, and putting nature on a pathway to recovery by 2030. That's not far away, is it? In 2020, the New Zealand government established Te Mana o Te Tao, Aotearoa New Zealand Biodiversity Strategy, which was submitted, as required, to the CBD. The framework contains obligations to monitor, report and review, including through regular national reporting against a set of global diversity indicators. Regular reporting to the CBD on its implementation of its strategy must include reports on progress against its objectives, goals and action plans using national indicators, and is to report on the country's efforts and hopefully to record that they're contributing to the global biodiversity goals and targets using the framework's monitoring framework. Our government is currently consulting on a second implementation plan to succeed its first launched by the previous administration. The new draft plan is attracting a little controversy, but it's not my purpose to examine that. My purpose is simply to address the CBD, the framework, and this country's obligations as relevant to my topic. The 2022 decision of the Conference of the Parties adopting the Convention on Biodiversity is a significant and wide-ranging document that I do not attempt to analyse in detail. There are, however, some features of it relevant to access to justice for the natural environment, which I record here. Paragraph 4 of the preamble urges, that's the word used, urges parties and other governments with the support of intergovernmental and other organisations, as appropriate, to implement the framework and in particular enable participation at levels of government with a view to fostering full and effective contributions of women, youth, Indigenous peoples and local communities, and society organisations and the private and financial sectors and stakeholders from all other sectors to that end. So there you're starting to get a flavour of access to justice through those vectors. Section H of the framework sets the global targets for 2030. There are 23 targets for urgent action, which, and I quote, need to be initiated immediately and completed by 2030. Targets 14 to 23 are tools and solutions for implementing and mainstreaming. Target 22 is pertinent to my inquiry, and I'm going to read it to you. Ensure the full, equitable, inclusive, effective and gender-responsive representation and participation in decision-making and access to justice and information related to biodiversity by Indigenous peoples and local communities, respecting their cultures and their rights over lands, territories, resources and traditional knowledge, as well as by women and girls, children and youth, and persons with disabilities, and ensure the full protection of environmental human rights defenders who come under some physical threat in places around the world. Hopefully not here. My interpretation of the framework is that it can afford a moral international, and I stress moral, international platform for access to justice for the natural environment, but that it may be construed as aspirational rather than directive in such measures as I have just quoted, except to the extent that such features must be the subject of monitoring, reporting and reviewing, and will be on display to the international and national arenas through those means. Interestingly, I also construe it as quite anthropocentric for a document which is about the protection of biodiversity. But that is no doubt the negotiated final position of the parties to the instrument. For the purposes of my present inquiry, the anthropocentricity does not detract. It simply amounts to a means to an end. I also offer the thought that the wider the range of perspectives, the greater potentially the benefit for knowledge about biodiversity and its benefits and importance. Now, back to the CBD, back to the treaty as a foundation document. Does it create obligations among states? I've said the framework is somewhat aspirational. Does the CBD create obligations among states? I think it's timely and pertinent in this regard to mention the very recently released advisory opinion of the International Court of Justice on obligations of states in respect to climate change. It is beyond the scope of my lecture to examine much detail of that landmark decision. It's big and it's complex, and to do so would require considerable time and thought. For present purposes, however, I note the very interesting references to biodiversity obligations identified by the Court from my brief research of the opinion. The CBD, which the Court called the Biodiversity Convention, is listed as part of an extensive description of applicable law, capital A, capital L. The opinion quotes Article 2 of the CBD, defining biodiversity in its very broad terms, and observes that in certain instances, and I quote, in certain instances, ecosystem protection measures may simultaneously operate as climate change mitigation or adaptation measures. So this is the world's top court talking. This document, as I've discussed with one or two of you here in the room over a drink, is going to be a blockbuster. It's going to take a very important place in society, I believe. The International Court of Justice held importantly that a handful of identified treaties and conventions, including the CBD, are, and I quote, the most directly applicable law to establish the customary duty, word duty, note the word duty, to prevent significant harm to the environment, and the duty to cooperate for protection of the environment and international human rights law, as well as certain guiding principles for the interpretation of various applicable rules and principles, which it listed as sustainable development, equity, intergenerational equity, and the precautionary approach or principle. And I will return to one or two of those concepts in this lecture. Paragraph 329 of the opinion seems to me to be quite powerful, so I'm going to read that to you as well. The Court further notes, they said, that pursuant to Article 7C of the Biodiversity Convention, states parties are required, as far as possible and as appropriate, softening again, but that's international conventions and treaties for you, as far as possible and as appropriate, to identify and monitor processes and categories of activities that have or are likely to have significant adverse impacts on the conservation and sustainable use of biological diversity. Where such significant adverse effects have been identified pursuant to Article 7, states parties have an obligation, there's that word again, as far as possible and as appropriate, there's the softening again, under Article 8.1, to regulate and manage the relevant processes and categories of activities, including those which contribute to anthropogenic GHG emissions. In this regard, the obligations incumbent on states parties to the Biodiversity Convention complement those set forth in climate change treaties, so far as the states concerned are also parties to those instruments. So I ask this question: do these obligations the Court speaks of advance the cause of access to justice for the natural environment? I say it would appear, maybe not directly, but again can possibly underpin the importance of the relevant provisions of the framework that I discussed a few moments ago in implementing the obligations contained in the CBD. I now turn to possible scientific underpinnings for my inquiry. Later in this lecture, I will make the case for practically all of our work in environmental governance and regulation to be evidence-based. And I want you to remember that phrase, evidence-based. You'll hear it again. What follows should illustrate the point. I'm not qualified in any branch of science and will not purport to advance scientific arguments. However, I have sat in judgment on the merits of many disputes involving many topics of environmental science for nearly 25 years, and I record a belief, put as objectively as I can, that I am qualified to recognise key and relatively robust scientific principles when I see them. So I'm going to venture into it. Many resource management cases I've presided over or have read concerning the natural world have focused on small numbers of species, often notable for being rare and endangered or otherwise vulnerable. Cases about a tern, a frog, a bat, or a lizard are important. These cases have often opened the door to developers and others to suggest that the small numbers of creatures involved can be sacrificed when weighed against the issue or weighed against something that they consider the greater good. There are, however, other occasions when the issue of biodiversity calls to be considered more broadly and holistically. For instance, when considering the fauna and flora inhabitants of a river or a wetland. My view is that the RMA encourages whole ecosystem functionality. Now, to examine that aspect in a non-legalistic way, I've reached for what I consider the top shelf for scientific and public policy context. In a moment, I set out a transcript, and I'll read it to you, of a YouTube video made 3 years ago for the Royal Society by the redoubtable Sir David Attenborough. Sir David Attenborough is remarkable in so many ways, not least because of his amazing filmography and his having attained 99 years of age and still going strong, but also his scientific qualifications from Clare College, Cambridge, in geology and zoology and natural sciences, and also his bewildering list of honorary titles from universities and scientific societies, and no fewer than 20 species and genera having been named in his honour by taxonomists. Wikipedia leads me to a CV for Sir David of 43 pages discussing the many facets of his life and career, with 277 footnotes and an extensive bibliography of his publications. So I think I'm right in claiming that I've reached for the top shelf in the scientific world. I note that he's had no fewer than 20 species and genera having been named in his honour by taxonomists. 20 species. 2 frogs, 2 lizards, and a lot else. The video, which I'm not going to play to you for reasons that I won't go into, it's a little distracting in the graphical area, but never mind. It commences with a striking example of a species of monkey performing ecological services by spreading seeds of trees which build up forests which absorb carbon dioxide from the atmosphere. There's a nice ecosystem description. He then moves to broad issues of biodiversity in quite remarkably anthropocentric terms, and they're interesting. So I'm just going to read to you a bit of the transcript of the video. He says, so, and I can't mimic his wonderful tones, so forgive me, you're just going to have to listen to my voice again. So, why is it so important that we protect our planet's biodiversity? When we think of protecting wildlife, we tend to picture the superstars, but the organisms that do most of the hard work keeping our planet healthy are the unglamorous ones. This biodiversity provides us with the food we eat. From the microorganisms that enrich the soil where we grow our crops, to the pollinators who give us fruit and nuts, and the fish that are the main source of animal protein for around 1 billion people. Many of our medicines originate from plants and fungi, and many more may lie undiscovered in remote corners of the world. For instance, there is a fungus that grows on the fur of sloths, is how he pronounced it, that could help treat some forms of cancer. The natural world shelters and protects us too. Trees and shrubs protect our homes from flooding, and coral reefs and mangroves shield our coastlines from storm surges. and all that is not to mention the great spiritual and cultural value that nature holds for human beings the world over. But despite the overwhelming benefits of a healthy planet, many human actions are destroying biodiversity. Changes to habitats for grazing, mining and crop production, including the use of harmful fertilisers, have had a huge impact on land and sea. Animals for meat and prized body parts. More than 300 mammal species risk being consumed to extinction. And then there's climate change. This affects the whole world, putting huge pressure on wildlife. In 2016 and 17, nearly half the corals of the Great Barrier Reef died as a result of the warming of the seas. So, what must we do now to slow down the crisis we are faced with? In addition to cutting our carbon emissions, we must find ways of using land and water that cause the least damage to the environment, leaving enough space for natural habitats to thrive. We must urgently protect the so-called biodiversity hotspots. But equally, we should be rebuilding biodiversity wherever and however we can. Sometimes this is as simple as giving plants and animals the space they need to succeed, and sometimes they need hands-on management from humans. You give some examples. In 2020, with the help of reintroduction experts in the south of England, white stork chicks hatched for the first time in 600 years. Bit controversial, perhaps. What about the woolly mammoth? What about the moa? But anyway, he said it. He then said hands-on management was also critical to restoring the population of mountain gorillas in the Virunga National Park in Central Africa. This included using a proportion of the money raised through tourism to help human communities coexist with their animal neighbours. Got a bit of an element of that happening here right now. Some might think it's controversial, some might not. He said we must provide pathways for global development that work with rather than against nature. And we need to give the communities affected a seat at the table. So I want you to remember that phrase too, please. My evidence-based one and this one, a seat at the table. I'll be coming back to it. The benefits provided by nature are indispensable for making human life both possible and worth living. We all need the riches of our living planet to help us live happy, healthy lives long into the future. I could just about end the lecture there. I think those are just beautiful words and so apt. With that one little element of controversy about reintroduction of species that have been extinct, perhaps. Now, my next inquiry is this: why should there be justice for the natural environment? So I'm moving from public policy and scientific underpinnings to philosophical or moral and legislative standpoints, express legislative standpoints. Famously, in a decision of a court in the States, the National Association of Home Builders against Babbitt, the US Court of Appeals on the DC Circuit drew on anthropocentric reasoning to justify protecting biodiversity. It's a theme that keeps cropping up. Things can be quite anthropocentric, surprisingly so, in this area. In upholding a provision of the Endangered Species Act, which I believe is a federal act, Judge Patricia Wald quoted extensively from the House report and the Senate report establishing the Act, citing philosophical and commercial reasons, and then held as follows, and I quote, "The variety of plants and animals in this country are in a sense a natural resource that commercial actors can use to produce marketable products. In the most narrow view of economic value, endangered plants and animals are valuable as sources of medicine and genes. 50% of the most frequently prescribed medicines are derived from wild plant and animal species. Such medicines were estimated as long ago as 1983 to be worth over $15 billion a year. Just imagine what the figure is now. In addition, the genetic material of wild species of plants and animals is inbred into domestic crops and animals to improve their commercial value and productivity. So you can see it's pretty anthropocentric. The judge cited, and I infer from evidence before her, two examples. Venom from a viper used in medicines that control blood pressure in humans. I'm quite venomous. And alkaloid drawn from a periwinkle used in medicines that are effective against leukemia and Hodgkin's disease. She reasoned that sheer self-interest impels us to be cautious. That's interesting. Philosophical underpinnings are pursued in a book, Critical Reflections on Ownership, by philosopher Mary Warnock of Oxford University in 2015. She addressed the different ways in which we view property, including property in the environment and parts of the environment that cannot be owned. She raises a question about human responsibility for the natural world and the planet as a whole, especially in light of what she describes as confronting global environmental degradation. It's beyond the scope of my paper to consider the approaches of some noted philosophers discussed by Warnock, but I'm attracted to her own consideration of human responsibility for wilderness, as she terms it, relative want of which worries her. In her chapter, Taking Responsibility for the Planet, she reviews what she hoped were emerging steps in the right direction from the early 70s. And makes her own review of progress after that time. She perceives a growing awareness of intrinsic values in society, for instance, justice. So that comes into my theme, saying, it is perhaps in pursuit of some such intrinsic value that environmentalists urge us to take responsibility for saving the planet, treating it as our own, rather as we may be asked to give money to restore a painting that is degenerating or a fine building that's on the verge of collapse. The final chapter of her book is titled, Why Do We Want to Preserve the Natural World? And it contains some quite deep reflections. Not myself being trained in philosophy, I do not engage closely with them, but I discern a focus, which I understand, I think, on a dichotomy of motivations, love and fear. They both resonate with me, probably in varying degrees and case by case. Warnock raises but dismisses another possible motivation, a sense of duty to those who will succeed us as inhabitants of the planet, arguing that one cannot have a moral obligation to an indefinite or infinite class of people. You can see me frowning. Having myself long subscribed to the concept of intergenerational equity as found in the RMA, I cannot agree with that last point. Later in this lecture, I will consider the tensions of current economic motivations for development against longer-term justice for natural environment, and I hope I will offer some rational accommodations of process to allow fairly for both. I identify that to foster one too strongly over the other, particularly development over future good natural states, may be to deny or lessen intergenerational equity and enable bad and even dangerous natural outcomes about which people like Sir David Attenborough will feel justifiably unhappy. Another book, hot off the press, a book charmingly called Is a River Alive? And I think you can see where I'm heading, is by Robert Macfarlane. It commences with a review of the history and advancement of the recent rights of nature movement, about which we've all read and heard quite a bit, and then offers three striking examples of rivers worldwide under threat of different kinds and how they and their supporters responded. His essential theme is that rivers are not mere objects for human use, but living beings who should be recognised as such in imagination and law. His first of three examples is in northern Ecuador, where wonderful cloud forest and its rivers are threatened with destruction by gold mining. The second is to the damaged rivers and lagoons of southern India, where a battle to save the lives of these water bodies is underway. The third is in northeastern Quebec, where a wild river, the Mute Kehau, Shipu, or Magpie River, is being defended against damming in a river rights campaign. The book offers a complex mixture of despair at pollution and over-allocation of rivers on the one hand, and hope springing eternal on others. The introductory chapter offers both. It mentions one positive example, which I experienced for myself last year, the Cheong-Yecheon stream in Seoul, in southern Korea, which has been daylighted by removal from above of an all-encasing concrete highway, and with a public park being created along its deep banks. It draws tens of thousands of pedestrians a day. Summer temperatures at the waterside can be 5 degrees cooler than surrounding areas, and air pollution levels along its corridor have dropped by more than a third. Queen Street, Auckland, anybody? It's been mooted in the past. Okay. Examples of bad situations in the book are harrowing, with some commentators lamenting conquests of nature around them and river taming. In his native England, Macfarlane decries a desperate calamity befalling many rivers and streams, a thing called shifting baseline syndrome, often being at the heart of bad human practices incrementally destroying water bodies and habitats. He argues that the reverse can be made to apply and succeed. I expected in the context of the international rights of nature movement to find, and I did in his book, mention of our Te Awa Tupua Act 2017, which famously, indeed internationally, accords the Whanganui River personhood as part of the legislation of the Crown's settlement with Whanganui iwi, in particular the historical claims relating to the river. And you'll remember as well that it doesn't sit alone. There's two mountain areas, Urewera and Taranaki, which have been accorded similar legislation as parts of settlements. So this is pretty central to my subject. It had been my intention when I started this project to research it and write about it accordingly. With access to Macfarlane's book, I'm able to do so set in the hauntingly written background and commentary of his writing. So he records, Macfarlane, in the book, this. Evidently the origins of the idea came from a young academic called Christopher Stone in California teaching property law in late 1971. That is, that rivers are live beings along with lakes, trees and animals, and should have legal personality. The students were evidently shocked, as was he initially. After considerably more thought, he wrote a paper in 1972 called Should Trees Have Standing?, followed by a book of the same name, still in print apparently after half a century. From my own examination of Te Awa Tupua Act, and in particular by Section 14, Te Awa Tupua is declared to be a living person with all the rights, powers and liabilities of such. Those are to be exercised through an office Te Pō Tupua, described in considerable detail in sections 18, 19 and 20 of the Act. Subsequent sections ensure that otherwise bothersome issues like funding, administrative support and tax are dealt with. Yet more sections establish, importantly, an advisory group and a strategy group and describe their functions in great detail. Collaboration in freshwater planning is strongly ordained. Provision is made for collaboration of many groups and entities who have guardianship, management, and a multitude of cultural responsibilities. RMLA planning documents are henceforth to be reviewed and amended to reflect the Act's provisions, and that, I imagine, must be underway. Certain kinds of legislative governance are terminated from 4 acts concerning the bed of the river and adjacent defined lands. By Section 41, the riverbed is vested in the new person, excluding certain public infrastructure works like bridges. Detailed consequential amendments are made to many statutes. Certain common law rules, such as accretion, erosion and avulsion, are expressly maintained. A register of hearing commissioners under the RMA is established. In qualifications of Section 95D and 104.3A2 of the RMA, consent authorities must not disregard any effect on Te Awa Tupua. Many other groups and functions are created around such matters as management of surface activities, regulation making power, coordination of fisheries activities, and customary food gathering, as well as the finding of any taonga tūtoru. All in all, the Act, I say, is a very significant, if complex, piece of legislation. I went in search of any resource consent decisions, also literature about how it may be working in practice, and I found an example of each of those. So that is information beyond available scholarly analysis, and there's quite a bit of it, of the legal and governance arrangements. I found an article in the International Journal of Human Rights titled "Beyond Legal Personhood for the Whanganui River, Collaboration and Pluralism in Implementing Te Awa Tupua Act." That really caught my eye. The article analyses two cases to do with implementation. Te Puaha, revitalisation of the port of Whanganui, and Te Kupuka na Te Awa Tupua, the collaborative group established to develop a strategy for the river. The three authors brought their differing academic qualifications and skills to conduct an empirical study involving interviews and conversations with many people on the ground in the locality. They also attended public meetings and other events and considered documents, press releases and other materials. Post-settlement governance entity Ngā Tangata Tiaki cooperated, indeed nominating one of the three authors to join that collaboration. I hope my following summary of the article does it reasonable justice. Suffice it to say up front, I interpret the author's reports about processes under and around Te Awa Tupua and the outcomes of the two cases studied as positive. And I'll tell you why. The authors say the Whanganui model reflects legal pluralism, acknowledging the existence of multiple intersecting systems of law, for instance what they call Crown law, with tikanga and kawa, producing an open, inclusive and ongoing dialogue. Almost the entire focus is the health of the river, but there is very wide inclusion of communities in all that is done and said. The port revitalisation case has been particularly instructive, I think. The port, having been built at a time of intense Māori land alienation and loss of power, but now being the subject of considerable degradation, and the river suffering from deep sedimentation affecting its health and making it largely inaccessible. Processing that port rejuvenation project under Te Awa Tupua proved an exceptionally steep learning curve for all involved. It essentially, the authors said, stood RMA processes on their head. For instance, entirely replacing traditional consultation with Māori with full-blown collaboration based heavily on marae-based tikanga. Numerous people and entities were involved. It appears that the time taken for introductory tikanga processes had a somewhat unifying effect on people, improving the quality of collaboration and ultimately the outcomes. Involvement seems to have been extended widely even to the likes of contractors and workers. A very big net, I think. Instead of seeking to avoid, remedy and mitigate effects in RMA style, the focus became how the project could promote a return to the original state of abundance in the river, thus replenishing and achieving Māori ora, Māori awa and Māori tangata for the environment, the river and peoples as a strategic goal. An issue about embankment rights blocking views onto the river was largely resolved by careful study and collaboration, although some affected persons were not entirely satisfied, but people evidently felt listened to, involved. This is interesting. One council official mentioned to the authors that this project, in his or her experience, was the first major development in the region not to have been subjected to higher legal challenges. Upfront cost of the project was acknowledged, I infer substantial, but participants thought this would be outweighed by benefits in the long run. All in all, a paradigm shift in ways of working, with much learning still ahead, with a need for planning, forecasting and resourcing to tangibly demonstrate local and central government's commitment to Te Awa Tupua. Having read that work of those three authors, I turned to the only resource management decision under Te Awa Tupua I could locate, that concerning the first stage of Whanganui District Council's port revitalisation project that was mentioned by the authors. It's a decision of the Horizons Regional Council, Manawatu Whanganui, and is dated 16 May 2022. Its sections Application Summary and Application Assessment discuss Te Awa Tupua underpinnings in considerable detail before describing the proposed works and assessing them against many statutory instruments and assessing their many environmental effects in recognisable RM manner. Its conclusion and substantive decision reiterate that Te Awa Tupua has been at the forefront of parties' approach and the decision makers' consideration. They stress the major collaborative approach taken and direction from Te Mata Puao, ensuring that Tupua Te Kawa have been upheld. And in a footnote in my paper, I tell you about Te Mata Puao as a hapu collective leading all this work. I discern significant congruity between the findings in the journal article I've been talking about as to process and community acceptance, and on the other hand, the assessments and findings of the decision makers in that 2022 decision. I strongly sense success, albeit from the processing of, at this stage, only one major project thus far. Te Awa Tupua is logically a major product of a treaty settlement, that being a constant flavour through the Act's provisions. The approaches of iwi-led inputs, community collaboration and general inclusiveness offer ways of doing things in the planning and consenting spaces that I think are new and exciting, and clearly give the natural entity, the river, access to justice at pretty much the forefront of the processes. I wonder aloud if there might in future be challenges in the aspect of proportionality for smaller projects and issues, but we'll see as time moves on. My hope is that proportionality, indeed also materiality, could be accommodated. It seems very logical that they should be. This was a big project, and there will be, I'm sure, small ones in future. The second case study by the three learned authors in the Human Rights Journal was concerning the strategy group Te Kopua Nā Te Awa Tupua as a permanent joint committee to act collaboratively to advance the health and well-being of the river. I think it's just as interesting as the discussion of the port revitalisation case. It revealed its own challenges and successes. The authors relate in great detail the wide membership of the group: iwi, local government, DOC, commercial interests and environmental and NGOs. Iwi appoint the chair and deputy chair, and its all voluntary, membership is unpaid. The main purpose of the group is to identify issues relevant to the health and well-being of the awa and develop and ultimately approve a strategy to deal with those issues. Te heke nahuru, to which, under the legislation, specified persons, particularly decision makers, are to have particular regard. aims were set in 2021 that it should produce a paradigm shift where all decisions taken about the river are based on intrinsic values, tupua te kawa, and that communities would take ownership, set priorities and make decisions, and that the Crown and local government should make the transition to this way of working. Work began on this in 2019 and has proceeded steadily through tikanga marae-based processes, with early emphasis based on relationships and building trust. The first draft of Te Heke Nahuru was released for public consultation in September 2023, maintaining the flavours I've described. It is intended that RMA authorities will have to reconsider their statutory documents in light of Te Heke Nahuru when it's finalised. Websites of Ngā Tangata Tiaki o Whanganui and Horizons Regional Council that I have visited to check progress indicates that submissions were to close in March 2024. These submissions can be accessed on the website Te Kopuka. I have been unable to find any further outcomes at this time, but I'm hopeful that this broad-based community process will maintain momentum in giving the river its true voice. The three authors considered that the processes they were studying through interviews and attendance at wānanga are bringing about major changes in governance, in the governance world, and that there's been a reversal of people's values and drivers where previously there had been a failure to recognise Indigenous value, law, rights, interests and tenures. They're inclined to emphasise the regime as bringing changes to Indigenous law rather than being a model for rights of nature. You can see me frowning a little at that. I think slightly inconsistently with that last proposition, they propose that it is an Indigenous sharing model by virtue of the fact that through relationality, abundance, working together, putting the river first, the Whanganui model benefits all. If they are correct in that last proposition, it seems to me the model is indeed both. It also seems to me that each side of the equation is good for the other. For the purposes of my present inquiry, the news does seem good. I've earlier indicated that the rights of nature movement is growing worldwide. As I completed drafting this address, my attention was drawn to a very recent article in The Guardian in the UK about a local authority voting unanimously and cross-party, happily, to acknowledge the intrinsic rights of the River Test, one of about only 200 chalk streams in the world. The councillors have ordained a situation in which the river is to be kept front and centre when making decisions on planning, land use, water management and biodiversity. The idea had been championed by a United States NGO, the Earth Law Centre, which sought a voice for the river in the legal system. The Guardian article, possibly quite naturally, expressly mentioned New Zealand's Whanganui River having been granted legal personhood in 2017. I am more than comfortable, as foreshadowed at the outset, answering my first question in the affirmative. I consider that science and international obligations of states require that there be access to justice for the natural environment. To what extent and how I will address in the next section of this paper, where I've blended my second and third questions. We have a slide change, thank you, Hadley. So the second and third questions, when blended, read, how can such access be achieved and what challenges will be faced? And I indicated to you early in my address that this is a more painful set of issues to address than that which I answered under the first question. I'm going to start with a plug for spatial planning to be enabled by statutory authority that ideally would place appropriate importance on the protection and enhancement of the natural world. As earlier mentioned, I strongly believe all our work on environmental governance and regulation must be evidence-based. Remember me stressing that before. Spatial planning should, I think, be the epitome of evidence-based planning. Happily, perhaps, the concept of spatial planning appears to be one of the least controversial of the topics being discussed in the environmental law reform space in New Zealand at the present time. Although, as an aside, I saw something on the platform, the Kaka, this morning that caused me to be a little anxious about amalgamation of government departments and what the flavour of those might be. They include the Ministry for the Environment and some more development-inspired departments. But let's stick with the positive. I'm now going to move to discuss again a little bit Te Awa Tupua, or perhaps derivatives of it, perhaps in several varying forms cascading to suit varying circumstances. The legislation very realistically recognises not only that its river needs a voice, but there must be means through which that voice can be articulated. It does that through a really quite elaborate system of guardians and other groups, emphasising building of relationships to achieve positive outcomes for the river, iwi and the wider community. As has been said in the Whanganui Port decision of the Regional Council, and by the three commentators I've quoted, traditional resource management type systems have been substantially upended to achieve that. The degree of wide community engagement appears to be the key. It is a far cry, and should be, from consultation as practised to varying degrees, or sadly sometimes not, under the RMA. I now identify some questions about how such processes as Te Awa Tupua could be more broadly applied. Te Awa Tupua came about, as I've said, as a key part of a Waitangi settlement. Quite large areas of New Zealand have witnessed settlements already, so the opportunity to extend the system by that means might now be a bit limited. The desirability of introducing access to justice for the natural environment, where settlements are not in view, means, for me, I suggest that the concept would need to be designed expressly for the natural environment. But that is not to say, however, that the cultural considerations should not feature. They could take as prominent a place as the protection and enhancement of the natural environment has in Te Awa Tupua. And so to do that might be considered to be honouring Te Tiriti partnership obligations. There might be a question of whether such an approach ought to be focused on notable natural features, or across the board, or with nuanced approaches on a scale of relative importance of the natural environments. My inclination is for the last position, picking up on what Edinburgh had to say in the video that so captured my attention. I next recognise that there are complexities and a not insignificant time element in Te Awa Tupua processes. The successful building of relationships and trust, particularly by tikanga means, while very positive, can be quite time-consuming. So I offer two thoughts about it. First, in comparison, what is not time-consuming and complex about current RM systems, leading aside for the moment as to the time element, fast-track systems, which I'm going to talk about shortly, I can't resist. I'm a bit taken with observations, learned observations, that Te Awa Tupua concept may result in limitation or avoidance of time-consuming higher court processes because the building of relationships and trust that has occurred. So the thing's turned on its head. You might have more time-consuming, even costly processes early on, but you get away from time-consuming litigious, legalistic processes later. Secondly, my suggestion a moment ago about nuanced approaches on a scale of types and qualities of natural environments might help. I return to my thought about proportionality and materiality in my discussion of the Whanganui Port decision. I am under no illusion, however, that designing such an approach could be challenging. Then again, I do wonder whether quite as many layers of authority would be as necessary as in the Te Awa Tupua world. Okay, what about fast tracking? I said I'd say something about it. I can't resist. Having myself played a central part in the fast tracking system into the COVID-19 recovery Fast Track Consenting Act 2020, I have a distinct concern about the potential impact on quality of decisions, including conditions of consent, under such time-restricted regimes. I also harbour a concern that processes as rigorous as in the new Fast Track Approvals Act 2024 may well meet challenges, particularly at higher court and judicial review level, that might contribute to overall timeframes not being as fast as legislators had hoped, in large measure because so many communities and nature have been disenfranchised. I personally would prefer to see more social licence underpinning the use of the fast track concept, if we are to continue to have it. For instance, limiting use of it perhaps to needed infrastructure and emergency works in the public interest. At the same time, I believe the natural environment should be given a seat at the table, remember that phrase of mine before, and greater flexibility introduced to the setting of timeframes for processes. There are some who have criticised what they call NIMBYism, red tape and green tape in resource management decision making. I do not deny that they exist, but as one who has been at the decision making coalface for many years, I say they are not nearly as prevalent and as is sometimes suggested. And decision makers are possessed of powers to manage processes efficiently and can be given more tools. So the Environment Court, for instance, has a practice note, most parts of which are designed to that end. Dealing with complex science, technical and cultural issues and inadequate preparation by applicants are much more often the cause of time taken in processes than any suggestion of NIMBYism, red tape or green tape. Stronger powers could be given to decision makers to help identify unhelpful attitudes among parties and to manage them. To do so might have the added benefit of lessening the scope for higher court processes, including judicial review. But we all know the High Court needs more business, desperately needs more business, don't we? Not? Right. Based on these views gained from experience, I consider it to be overreach to disenfranchise the natural environment and communities in the stated interests of speed of fast-track consenting. There can be expedition and efficiency in processing applications for large projects, for instance, direct referrals to the Environment Court and boards of inquiry. They are first instance hearing exercises, hence often involving hundreds of submitters as well as dozens or more of complex substantive topics, a phenomenon employing the adjective polycentric. I personally have experience with both types of consenting, the boards of inquiry being required by statute to complete their work within 9 months of a statutory trigger date early in the process. And as to that methodology, that type of process, as Peter Salmon indicated when introducing me, there was the Waterview Motorway Board of Inquiry, which I presided over, and was a very big project, and it was done on time in 9 months. We were pretty tired at the end of it, I can say, but we did it. As to direct referral, again picking up on Peter's, the case re Waiheke Marinas Limited, which was a proposal for a boat marina in Matiatia Port, ferry port on Waiheke Island, in which the number of submitters was so great and the number of issues so numerous and the topics highly controversial in the community, that we placed a bolded significant preface on the decision, exhorting readers to take the time to read the entire decision, not just aspects of interest to them. That was a marina my panel turned down. I next turn my attention to the concept of environmental defenders. In New Zealand, there is great reliance in the public domain on NGOs undertaking litigation and education and making public statements in defence of the natural environment. I do not single any of them out because it would be embarrassing to miss any. We all have a good idea of who they are, and there's a number of very effective ones. NGOs currently operate in trying financial circumstances. Government funding, which could never have been described as generous, has now been cut. Heavier reliance has therefore been necessary by the NGOs on public donations and on pro bono representation by professionals. My assessment of the importance of the natural environment worldwide earlier in my paper should no doubt have created an expectation that by and large I approve of the activities of these organisations. They have achieved notable success in many important cases in the courts over many years, richly illustrated in the book that Peter mentioned, the recently published book Environmental Defenders by Rowan Peart. Spoiler alert, I feature in the book as a cub lawyer in the 1970s, along with many other environment professionals who've gone on to make their mark in society, including as judges. It was a great place to cut one's teeth, and it was nice when we actually achieved something too. The NGOs are not, in my experience, the source of NIMBYism, red tape or green tape. They bring serious issues to the attention of society and before the courts. They have a high success rate in court. Having identified the importance of the natural environment in this paper, I advocate that there be a system of public support for these NGOs that lessens the tenuous nature of their current funding methodologies. For instance, I look across the Tasman at the Environmental Defenders offices in each of the states and territories in Australia. I note the mix of government, public and private funding for that office, for those offices, noting also, however, that they do have the relatively common use of pro bono representation from professionals. Government funding was removed from them in 2013, but it was reinstated in 2023. They're incorporated jointly as a limited liability company and registered as a charity. It appears that they are in a significantly better position than our NGOs in this country. Like our NGOs, they have achieved high levels of success in defence of the natural environment. A study of their website is interesting and instructive. I commend it to you. One benefit of representation of the natural environment by environmental defenders is that professional activity offers almost invariably higher quality cases and also reduction of involvement of less skilled participants who can slow down the progress of cases if not managed assiduously by the decision-making bodies. So now a few minutes on fostering access to environmental justice more broadly. Definitely relevant to the questions in my lecture. Time does not permit me to discuss it at length here. Much has been written on the subject by judges and noted academics in the field around the world. It will be sufficient for my present purposes to point to some of the presentations by such people at an international symposium organised by me and others in Auckland in 2017. The papers were published in a special issue of the journal Environmental Law and Management. The keynote address was given by Lord Robert Carnwath of Notting Hill, then a Justice of the Supreme Court of the United Kingdom. Lord Carnwath lamented the fragmented system of environmental governance and adjudication in the UK. He quite flatteringly compared New Zealand's and New South Wales's system, particularly the part played by specialist environmental courts. China came in for a mention from him with its burgeoning of such courts in recent years. I actually went to the opening of one in Kunming a number of years ago. Evidently, NGOs in China have significant right of audience in such cases as involve environmental concerns for the Yangtze River Basin, illegal logging and fires started by negligence such as cases enabled by promulgation of their Environmental Protection Act 2015. His paper is a very learned and compelling read about many issues of access to environmental justice in many countries, and I commend people to read it. or reread it if they've already seen it. The paper from that symposium that holds particular resonance for my lecture here tonight was delivered by then Hon Justice Stephen Koch as President of the New Zealand Court of Appeal, now Hon Sir Justice Sir Stephen Koch, member of our Supreme Court. He offered the opening address for the symposium. Referring to contributions to the symposium by others and other writings and speeches, Justice Koch addressed, among other things, access to public participation and access to justice in environmental matters as one of the elements of the 3 pillars of the environmental rule of law. I find his remarks and guidance helpful, even though he didn't employ the words "for the environment," because it was actually about voices for the environment, which is part of my theme. He remarked that New Zealand had made progress in lessening its previous restrictions on standing in the environmental field, but he warned that recent reforms have begun, he said, to create quasi-standing barriers. With hindsight, I find that rather perceptive when measured against our more recent fast-track reforms that I've discussed in those terms. So Stephen spoke again, as he has in the past, about David and Goliath situations and inequality of arms in environmental litigation, potentially resulting in poorer outcomes. I subscribe to that theory. I understand it. He expressed concern about the then minimal environmental legal assistance fund situation. Of course, we now know that that's gone. He contrasted the Australian and Canadian environmental defenders officers and their better off situations than for our NGOs in this country. He felt that the Environment Court and Boards of Inquiry could more often consider appointment of counsel to assist in major infrastructure project inquiries. I feel the sting for not having done so myself. He said such counsel could be appointed and should even be able to call expert evidence. And what's not to love about that? He contrasted the Australian and Canadian environmental defenders officers again. He favoured hearing bodies appointing friends of submitters in these cases. I feel a little more comfortable about our record there. So Stephen noted a past High Court case in which a major NGO, that's in New Zealand, was required to post a significant undertaking as to damages in a coastal erosion case on appeal. He felt more favourably disposed, I say understandably, to an Environment Court decision in which such an application had been denied. In a lengthy section of his paper, he worried about the disincentive for community interest groups, which I call voices, of the Environment Courts and High Courts' powers to award very significant sums of costs against unsuccessful parties. He offered some examples, although in one, which happens to be a case over which I presided, the small local community group actually is recorded as having failed miserably to act responsibly on appeal. So I don't feel unhappy about that. Of some moment concerning such risks of costs awards, Sir Stephen offered what he termed a possible modest innovation that could be considered in environmental litigation and for which there is a precedent in trusts law, it's called a preemptive protective costs order. Essentially a shield where certain factors are demonstrated, such as issues being in the general public importance, the public interest being in having the issues resolved, the applicant for the order having no interest in the outcome of the case, no personal interest, regard being had to the financial resources of the applicant, and the possibility or even likelihood that the applicant would discontinue if the order were not made. He noted that such orders have not been made in environmental litigation, but that, and I infer by over to the Supreme Court in the King Salmon decision, appeared to have anticipated that it might occur. Pointing to Section 285 of the RMA, which is the Environment Court's broad power concerning costs, he offered his view that that court has such jurisdiction. I won't venture on the issue. I'll leave it for others to explore in the future. So I come now to my conclusion, and I'll be quite brief, but I hope quite direct. As I've said, I've found no difficulty answering my first question, should there be access to justice for the natural environment, in the affirmative. I have arrived at that position by consideration of national and international legislative provisions, public policy and scientific contexts, and philosophical and tailored legislative standpoints. The harder questions arise when inquiring how such access can be achieved and overcoming challenges. And this, I think, is a fairly important factor. The environment is a complex thing. So I say that it is unavoidable that the regulating of human endeavours in relation to it will be a complex matter. I've analysed te aba tupua, or possible derivatives, for a way forward. I express concern about tensions between good access to justice for the natural environment and movement towards time-limited decision-making. I have considered various manifestations of environmental defenders. I've also examined issues and challenges for access to environmental justice more broadly, including as to legislative structure, differing models of hearing bodies, and costs regimes of courts and tribunals. All these matters and more will require a great deal of work, but should not be insurmountable if addressed in a willing and constructive fashion. I say the efforts would be well worthwhile. Thank you. Okay.
Thank you, Judge. Please don't go anywhere. We now move to questions, and I believe there is a roving mic and some questions possibly online. So, who's going to be first?
Start off easy, Laurie. Thank you very much. Without getting to the detail, and maybe at the risk of being slightly off topic, in terms of access to environmental justice, what role do you see for RMLA in terms of what we're facing at the moment? And I'm getting into do we have a role to inform policy or not?
You've probably got to go back to your constitution to answer that.
We're currently reviewing.
Oh, yeah, good. Okay, well, here's something you might do. Look, being as objective as I can about this, RMLA has been very careful throughout its life to avoid taking strong policy positions on matters where its broad church of membership might well have strongly differing ideas about those policies. So I think rightly it's actually been very careful about them. I've discerned in more recent times where there are matters of considerable importance, and often I think after survey by RMLA of its membership, that it has ventured a little more strongly upon matters of policy. I think it's important that it do those surveys, and if it detects major divisions within its memberships, it would probably still want to be quite careful. It might encourage other groups to step up and comment on policy. I'm not saying that it shouldn't be involved, but it's always been careful, and I suspect it will always be a bit careful because of varying views among its members on matters of policy. It does a great job. I love the RMLA. Other questions?
Tēnā koe, Judge. I just had a question. When you say that the environment needs a seat at the table, is that from an Indigenous perspective or is that from a Western perspective?
Both. I'll say this, and I said it in a recent major decision about tikanga matters. I am wowed by the extent to which matters of Western science on the one hand and tikanga mataranga coincide. And it happened in the case in which Judge Michael Dugan, who's here, and I issued an interim decision in recent times, and we said so. So it's both, and we are pleasantly surprised very often about the intersection of those things.
Other questions?
I've frightened you all off. Oh no, Martin's going to leap into the breach.
Thank you, Laurie, for that incredibly thorough and thought-provoking assessment of the issue from an international law context, philosophy, one of my favourites, David Attenborough, through to your thesis in a local context. Is it a case of access to environmental justice denied can mean environmental processes delayed? If I could put it that way, that you can actually get faster, better outcomes if you do give the environment a seat at the table. Is that something you'd agree with?
The short answer is yes, Martin. I strongly agree with that proposition. And I think I hinted at it at one or two places in my paper where I talked about NGOs being able to do the heavy lifting and bringing a professional approach that might lessen the need, and this is just one example, lessen the need for less informed but well-intentioned people slowing processes a bit. I also subscribe to the idea that the quality of outcomes is vital, and that if, for instance, in a time-constrained hearing situation like fast-tracking, a panel is unable to come to a sound decision and issue sound conditions of consent, that flaws, if I can put it that strongly, in such a decision might well come back and bite not just the environment, but also the people living in that environment. And that could even be in economic ways. I won't try and trot out a whole lot of examples, but there are plenty going through my head.
Last chance. Anyone?
Tēnā koe iwi rangatira. This question doesn't reflect my interests, but it does reflect some of the commentary in political circles. With your thoughts around access to justice for the environment, where would you see private property rights in that system? As I said, not my interest.
In the first or the second sentence of my address tonight, I did say I wasn't going to venture upon political matters. All I will say is that I wait with great interest to see how that might play out. I'm also a little bit interested, I'm trying not to be controversial. I've noticed, I think, as I've said to one or two of you this afternoon or this evening, that I think there may be a realisation dawning among the executive that this thing reform is bigger than Texas. I've noticed in recent weeks that we're now being told that the outputs will arrive in 2027. It slipped from 2026. It is complex, as I said in the penultimate paragraph of my address. It's complex, and it requires complex work and complex work by all concerned. So I'll wait with great interest to see where private property rights lands. I will also await with great interest to see how the division of governance into two statutes, one, if I can be a little bit crude about it, urban, and the other sort of non-urban. It's going to be really interesting. That's all I say.
Thank you so much, Judge. That was fantastic. I was reflecting on the last David Attenborough show I did watch, where I must admit I was most upset at watching some of the environmental degradation. So you certainly brought that back to my mind, which I think is a positive. But thank you very much for the time you've given us tonight. And I've just got a small token of our appreciation. And
Thank you so much.
I hope everyone will join me in saying thank you. I also just have a small token for you, Peter, for being here 25 years on from the first one. Thank you very much. So thank you, everybody. The bar is still open, so grab a drink and join us for a bit of chat. And don't forget about the books just to the right.